2015 has seen the Law Journal mark 40 years since its founding as the UNSW Law School's flagship publication. We are delighted to be the custodians of its continuation and expansion. Legal scholarship is important. Fundamentally, it enables us to critically analyse whether our law is principled, just, and adapted to its current environment. Where it is not, it asks how it might be improved. The journal is deeply committed to enabling original contributions to the analysis of our legal world. As many of you will know, this year has marked a shift to 4 issues per year, quite simply made possible by the volume of high-quality submissions. Under the journal's rather unique publication structure, articles on matters right across the legal spectrum are published in a general component of each issue, and a collection of perspectives on a single topic of high contemporary importance forms a thematic component of each issue. This structure allows the journal to achieve 2 key goals. On the one hand, contribute to scholarship on a wide range of subjects in the Australian legal landscape, and on the other, stimulate discussion and debate in an area deserving of particular attention. Since 2013, the journal has also published outstanding student articles on the Social Sciences Research Network in the UNSW Law Journal Student Series. The Student Series consists of the best research theses produced by students at UNSW and offers a stepping stone into the world of academic publication. As many of you will also be aware, we as a journal are very proud to be entirely student-run, as we have been throughout our history. That a student-run journal has been able to maintain sufficiently high standards so as to be regarded amongst the best peer-reviewed legal journals in the country is a reflection of 40 years of hard-working students. Looking at the current editorial board, I have no doubt this success is poised to continue. On the editorial board's behalf, I would like to express my gratitude to Premier Sponsor Herbert Smith Freehills, our hosts this evening. The firm has been a great supporter of the journal for decades, having been involved since 1982, then as Freehill, Hollingdale and Page. It almost goes without saying that the journal could not be in the position it is in today without your support. I thank Herbert Smith Freehill's partner Rebecca Marsden-Stanage for representing the firm here this evening, and Carly Miles, graduate recruitment consultant, for her considerable assistance in bringing tonight together. I would also like to thank the journal's other 2 sponsors, Allens and Kingwood Mallisons. We are also appreciative of the continued guidance and advice of the Law Journal's faculty advisors, Associate Professors Lyria Bennett-Moses and Michael Handler, and Dean of the UNSW Law School, Professor David Dixon. Being student-run, the work of the journal's board members deserves particular praise. This issue is the result of the hard work of 28 voluntary board members who have put in significant time and effort to bring this issue to print. Thank you to all of you. Finally, my last thanks go to Zhongwei Wang, the editor of issue 38.3. Zhongwei has piloted this issue from its inception as a call for submissions 1 year ago through the stages of peer review, editing, and most satisfyingly, printing. Anyone who knows Zhongwei would agree that the descriptors prepared, diligent, and thorough barely scratched the surface of his efforts. Such was Zhongwei's proficiency, he has produced a record 14 articles in a single issue and beaten all deadlines along the way. Now, many of you may not know that Zhongwei is actually an identical twin. If we are honest, his efficiency did make us wonder whether his ability to devote long hours to journal work was perhaps the result of some covert work-share arrangement with his twin, Barry, who's also in attendance this evening. But Zhongwei, it is a testament to your work ethic that the work you've completed yourself could have been that of 2. With that, I would now like to invite Rebecca Marsden-Stanage, partner at Herbert Smith Freehills, to speak on the firm's behalf. Rebecca is widely recognised as a market-leading expert in mergers and acquisitions and capital markets. In 2012, she was named Lawyers Weekly Australian Dealmaker of the Year and has advised Australian and international clients across the agribusiness, airports, construction, food manufacturing, media, mining and resources, and retail industries. Rebecca acted on the restructuring of the Centro Properties Group in 2011, widely accepted to have been one of the most complex corporate restructurings in Australian history. The Journal is very grateful for Rebecca's time this evening. Thank you, Rebecca.
Thanks very much, James. Look, here at Herbert Smith Freehills, we're incredibly proud of our relationship with the UNSW Law Journal and delighted to be hosting tonight. Great to see you all here. And I was having a look at the thematic and the general components and just reflecting, because you've got a 40-year proud history here. I left law school 20 years ago, which feels a long time, but as I looked at what's covered in issue 38.3, I tried to think, what would I have thought when I was at law school, looking at what you've covered in this very impressive volume? And I thought I would have been utterly confused. So we've got Jody Saganto, collaborator cybersecurity cartographies, and covering, among other things, the Privacy Commissioner, serious data breaches. There's coverage of the ACNC. I would have not made anything of that. I still don't know, even now, what making the most of shared laws and their juris consultorium is, but I think I especially would not have known 20 years ago. There's the red tape reduction agenda, and of course anti-bullying provisions in the workplace. They would have been entirely foreign concepts to me. And it just occurred to me what a valuable function your journal performs, because I kind of memorised my law back in 20 years ago, and to keep it contemporary, you couldn't rely on me. I'm busy doing mergers and acquisitions, but you guys are out there thinking of what is current, what's interesting, sourcing really fascinating articles on these topics. And so when I need to get up the curve, I don't need to go and do this myself. I can flick through your journal, and that's a really valuable function that you're performing. Now, James mentioned, and it's a great honour to see the effort that you've all made, but this is an entirely student-run journal, and I'm sure it takes enormous work. I've been speaking to some of you about how much work it does involve pulling these together. So, great work. We really appreciate it. Looking forward to digging into some of those articles and educating ourselves on the latest current thinking on so many topics. I'm glad you threw in a few more old-fashioned ones as well, just for us old folk. But when I'm talking about people working so hard, I am delighted to hand over to Zhongwei Wang, who is no doubt the person who has worked the hardest on this particular issue. Congratulations, really looking forward to reading it. Proudly introducing Zhongwei Wang.
Thank you, Rebecca. Distinguished guests, ladies and gentlemen, it is with great pleasure that I welcome you to the launch of issue 38.3 of the University of New South Wales Law Journal. As James has mentioned, each issue of the journal comprises two important parts, a general and a thematic component. The general component of this issue contains 10 articles, addressing a wide range of contemporary issues. The articles explore issues in estate law, such as the contemporary relevance of Banks and Goodfellow and a year of case law on estate contestation, the growing body of internationally shared laws and their implications for commercial law practitioners, theories of regulation, including analysis of the government's red tape reduction agenda, and a positive theory of effective regulation, a proposal to split the Australian Taxation Office, the anti-bullying provisions in the Fair Work Act, and topics in public law, such as statements of compatibility under the Human Rights Parliamentary Scrutiny Act, and the 2014 High Court 2014 statistics for High Court constitutional law cases. The general component also includes a review essay that critiques two recently published books on alternatives to adversarial court processes. The thematic component of this issue contains 4 articles addressing inquiries conducted by the executive and legislative arms of government. Commissions of inquiry find their roots in the Doomsday Survey of 1086. These ancient institutions have not lost their contemporary relevance. Royal commissions are regularly called to investigate potential misconduct. Executive agencies, like the Office of the Australian Information Commissioner, may inquire into alleged breaches of the statutes which they administer. Meanwhile, bodies such as Senate committees and national human rights institutions can conduct inquiries to provide the impetus for law reform. The articles in the thematic component of this issue examine these varied types of inquiries. In doing so, they answer questions like how inquiries are conducted, what purposes they serve, and how they interact with other institutions of government. I hope that they will be useful in clarifying our understanding of the operation and roles of inquiries. This issue has been the result of the hard work of many individuals. I would now like to take this opportunity to acknowledge their support. First, I would like to thank Professor George Williams, Dr. Paul Kildare, Dr. Greg Weeks, and Mr. Nicholas Cowdery for their insights on the various areas of law that relate to commissions of inquiry. I would also like to thank the Dean of the UNSW Faculty of Law, Professor David Dixon, and the journal's faculty advisors, Associate Professors Leroy Bennett-Moses and Michael Handler, for all their assistance. Second, I would like to acknowledge our premier sponsors, Herbert Smith Freehills, Allens, and King & Wood Mallesons. The journal would not be able to continue its activities without their ongoing support. Third, I am grateful to the Honourable Justice Peter McClellan, Member of the Order of Australia, for writing the foreword to this issue's thematic component. As the chair of the Royal Commission into Institutional Responses to Child Sexual Abuse, his insights are a truly special contribution to this issue. Fourth, I would like to thank the authors for producing the outstanding articles in this issue. I would also like to thank the anonymous peer reviewers who have greatly assisted us in making our publication decisions. I am also indebted to members of the journal's editorial board for editing the articles with extreme pedantry. I would particularly like to acknowledge the editors who volunteered to take on additional edits. My final thanks go to the journal's executive editor, James Norton, and my fellow members of the executive committee. It has been a true privilege to work with this unique team of incredible people. I would now like to introduce the Honourable Mr. Terrence Cole, Officer of the Order of Australia, Reserve Force Decoration and Queen's Counsel, who will deliver the keynote address tonight. Mr. Cole is a former judge of the New South Wales Supreme Court and Court of Appeal. Between 2001 and 2003, he served as the Royal Commissioner for the Royal Commission into the building and construction industry. In 2005, Mr. Cole was again appointed as Royal Commissioner for the inquiry into certain Australian companies in relation to the UN Oil for Food programme. Having twice served as a Royal Commissioner, Mr. Cole is well qualified to give us an insider's view on the operation of non-judicial inquiries. And on that note, it is now my pleasure to welcome the Honourable Mr. Cole to deliver the keynote address.
Thank you. May I say in advance that I'm an old-fashioned black-letter lawyer. But it's almost 10 years since I had the privilege of launching volume 29.3 of this journal, which had as its theme public-private partnerships. This evening I have a similar privilege regarding volume 38.3, which has as its theme non-judicial inquiries. This difference in topics highlights a notable aspect of the University of New South Wales Law Journal, namely the manner in which it seizes aspects of the law which are, at the time of publication, of contemporary interest and importance. And it's able to attract deeply thoughtful and scholarly contributions addressing such issues. There is no doubt that is because of the recognised high standing of the journal and its law faculty. And this volume upholds those high standards previously set. It's not to be overlooked, and you won't have overlooked it because you've heard it 3 times, but you're about to hear it a 4th, that this volume contains much more than articles on non-judicial inquiries. In the general component, there are articles about testamentary capacity, contesting estates, aspects of commercial law, prescription in law and its relationship to red tape, designing effective regulation, accountability and fairness in relation to the Australian Tax Office, anti-bullying provisions in the Fair Work Act, evaluating statements of compatibility under the Human Rights Parliamentary Scrutiny Act, statistics concerning the High Court's approach to constitutional law, and an essay on the non-adversarial justice and possible consequences for the court system. Only a person barren of mind or devoid of interest could fail to find stimulation in reading the volume. Reading these articles drew to my mind the great developments which have occurred in the breadth of study of law since I completed my degree 55 years ago. Then we studied contracts, torts, equity, constitutional law. We were taught to keep quite distinct concepts of law and sociology. We were taught that every right had a commensurate obligation and both must be considered. This does not at present seem a fashionable notion, with rights being emphasised and obligations disregarded. Professor Julius Stone taught us international law, but its principles appeared to be of little relevance to someone intending to be a solicitor or to practice at the bar. The great blossoming of concepts of human rights and international obligations, which flowed from principles founded or espoused by the United Nations, had barely begun, and administrative law, as we know it today, did not exist, nor did environmental law. They were, by today's standards, simple times. Research was conducted by reading judgments and textbooks. Commentary, discussion, and analysis were not instantaneous. There was no internet, and access to international thought was limited. Yet, to the wonderment of some of today's younger generation, society and the law got by, and legal thought expanded to cover a great width and diversity of topic and scholarship, a sample of which is exhibited in this volume. The theme of this volume is non-judicial inquiries. That assumes there are judicial inquiries. It is immediately to be recognised that it is not a function of judges to conduct inquiries. Their function is to decide and resolve disputes between contesting parties, be those parties state, corporate, or individual. Judges have no investigative powers. They resolve disputes by hearing competing contentions on disputed matters of fact, law, and relief. They make orders binding only on the parties involved. It is integral to a proper understanding, proper working of our society, that the authority of the courts be maintained and its orders obeyed, for otherwise society descends into anarchy and the rule of power or wealth rather than the law. It is that concept of the rule of law and the concomitant notion of the independence of the judiciary that has led most Chief Justices to refuse to permit judges of their court to sit on administrative inquiries established by the executive. Such inquiries report to government, which may act or not act on the inquiry's findings or recommendations as it sees fit. Such inquiries make no binding, enforceable findings or determinations. Governments wish to have judges conduct inquiries for them because of the recognition that the high standing and independence of judges recognised by the community gives credibility to the findings made by the inquiry. But because findings so made by the inquiry may not be acted upon, and because the matter inquired into may involve political considerations which might result in perceptions of absence of impartiality, it has been seen as of critical importance to separate the judicial function from that of administrative tribunals or inquiries, and rightly so. And that also explains why, frequently, retired judges are appointed to conduct administrative inquiries, including royal commissions. Governments get the standing, the independence and the authority of the retired judge without the separation of the state in the form of the executive and of the judiciary being impinged upon. And the rule of law is thus preserved. Once this critical aspect is understood, it is acceptable to refer to non-judicial inquiries, for in popular parlance, that carries the understanding of matters inquired into, but not in the courts. It is such inquiries that the thematic papers in volume 38 address. Miss Fiona Ruffley has addressed the topic Royal Commissions and Contempt of Court, the effect of curial proceedings. The paper addresses, and I quote, the effect of the law of contempt on the executive's power to establish and the power of the Royal Commissioner to conduct inquiries on matters also the subject of legal proceedings. The issue addressed is whether proceedings of the Royal Commission may themselves constitute a contempt of court, and thus the power to establish a Royal Commission may be curtailed, or if it's established, the conduct of the Commission may be restrained by injunction. The author's conclusion is that whilst the law requires that where the conduct of a Royal Commission can truly be said to create a risk of interference with the administration of justice, its activities must be curtailed to avoid that consequence. And I quote, the courts have shown a significant reluctance to restrain the activities of Royal Commissions on grounds of apprehended contempt of court. She concludes that the application of sound discretion by the courts has resulted in the avoidance of prejudicial conflict between the conduct of Royal Commissions and the administration of justice in the courts. All compulsory inquiries are established by government. They are a delegation by government to a nominated individual or group of the executive power to perform nominated tasks which are usually carefully identified and described. Such inquiries are not intended to interfere with or conflict with the separate and distinct tasks of the judicial system, but occasionally they might. Royal Commissions are invariably inquiries into matters of public interest. Traditionally, they fall into two categories. First, where there is such public disquiet regarding certain matters that the government forms the view that there should be a commission to determine the factual circumstances and recommend appropriate action by government, the so-called investigative commissions. Second, where the government requires advice regarding approaches it might take regarding reforms, the so-called advisory commissions. The former is the more usual. People or organisations being investigated hate it. Invariably, they want to deter, limit, and hopefully stop the inquiry. Usually, they are well resourced to try. Every avenue to restrict investigations and hearings to prevent publication of the report will be pursued. it necessarily follows that those conducting such an inquiry need to be aware of, or at least alert to, the pitfalls into which they may be induced to tread as a precursor to an application to restrain the Commissioner from proceeding. I was subject to 8 such applications, each fortunately unsuccessful. Royal commissions can be curtailed or stopped only in a very limited number of ways. First, if the Royal Commissioner strays beyond the scope of his terms of reference when properly interpreted, he's beyond his jurisdiction. And second, if the Commissioner denies to the person or entity being investigated natural justice. It's an aspect of this second limb that Ms. Ruffley addresses. She addresses the circumstances in which the powers of a Royal Commission might be restrained because of the possibility or actuality that existing or proposed civil or criminal proceedings related to the subject matter of the Royal Commission might constitute a contempt of court. She gives a clear analysis of the current High Court authorities in respect of which she, and I must say I agree with her, concludes one can only say that the law is clear depending upon which bench of the High Court sits. Her work is a valuable addition to learning on this subject. Would you mind? Thank you. Dr. Saganto and Mr. Mark Burden have written a paper entitled, thank you, The Privacy Commission and Own Motion Investigations, OMIs, into Serious Breaches, a case of going through the motions. They address an important topic, namely the circumstances, manner and competence of own motion investigations into serious data breaches by the Office of the Australian Information Commission, the OAIC. The paper is based on an examination of 6 OMIs into serious data privacy breaches, the information containing these breaches having been obtained through Freedom of Information requests. The investigations were conducted between February 2011 and July 2012 and involved alleged privacy breaches concerning names, addresses, driver's licence numbers, credit card details, letters addressed to persons but containing information relating to non-addressees, passwords, and similar serious breaches. The OAIC found that there had been breaches of national privacy principles in 5 of the 6 cases examined. Black lawyers like me might have thought that was enough. But the authors are critical of the OAIC on many bases. Let me give you some indication of those. They are critical on the basis of selecting matters to be investigated by the OAIC, of the process of investigations, of their failure to follow their own self-prescribed procedures, of their failure to use conferred compulsory powers, of their reliance on reports prepared on behalf of those who were accused of the breaches, of absence of vigour in pursuing evidence, of lack of clarity on the basis of the decisions made, of the absence of skilled personnel working on these topics, inadequate funding to enable them to perform their tasks, and of their preparedness to reach outcomes with those accused of breaches by negotiation rather than determination. The authors suggest that those deficiencies and the decisions to conduct the OMIs may have been part of a scheme by OAIC to seek to encourage the enactment of legislation requiring compulsory notification of privacy breaches to those affected, a position not yet legislated in Australia. The warning I would give to the authors is that they should not expect the Privacy Commissioner to welcome their review. However, the matters they raise are serious matters of considerable concern to modern society. The paper by Ms. Seymour and Naim is headed the ACNC, the Senate, the Commission of Audit and the Not-for-Profit Sector. ACNC stands for Australian Charities and Not-for-Profit Commission. I found this paper interesting, although in my view the paper addresses a political issue rather than a legal one. The question addressed is whether a reform in the manner of regulation of the not-for-profit sector introduced by the Gillard government should be repealed, as the Abbott government promised it would prior to the last election. It is now seeking to achieve in the Parliament in pursuance of that promise. The authors are firmly of the view that it should not be repealed. The paper starts with statements that one needs to have three streams, namely problems, policies and political streams if you're going to achieve reform. It says you need consensus of understanding of the problems and of the preferred solution to achieve that change. Part 2 addresses, I quote, reforms by the Gillard government that help set the consensus understanding of the tripartite problems of the not-for-profit sector and the preferred solution, end quote. The so-called preferred solution was the establishment of the ACNC in 2012 as a central regulating and administering body in the not-for-profit sector. Part 3 commences by noting, and I quote, however, the incumbent coalition government's Liberal majority prior to its election in September 2013 did not support such an introduction, and as such the coalition asserted on several occasions their intention to dismantle the new regulatory regime. They record that the stated reasons for doing so were, and I quote, reducing regulation and costs, it being argued by the new government that ACNC added an unnecessary regulatory burden to the charity sector. They then quote the present Minister, Mr. Andrews, I quote, given the regulators in place before the Commission was established can provide similar regulatory oversight at a lesser cost, both in terms of administrative cost to government and in terms of costs imposed on regulated entities. The introduction of a specialist regulator to monitor and enforce a codification of generally applicable laws has not proven to be the best use of Commonwealth funding, end quote. After its election, the current government introduced the Australian Charities and Not-for-Profits Commission Repeal Act No. 1 as the first step to repealing that which had been enacted in 2012. The authors then write, and I quote, all this raises the issue of whether the policy stream aligns with the political stream. Is there a policy consensus for the current proposal? From a review of the government's attempt to abolish the ACNC, the answer is no, as the government has found it challenging to roll back the reforms initiated by the previous government, end quote. The repeal bill passed the House of Representatives. In the Senate, it was referred to its Economic Committee, which was to conduct an inquiry and to report. This it did. Part 4 addresses the Senate's inquiry and report. Unsurprisingly, after having considered the submissions received, the committee reported on party political lines, with the government members producing the majority report supporting abolition because the ACN had, quote, significantly and unnecessarily increased red tape for many charities, end quote, and the dissenting report by the Labor and Greens representatives opposing the repeal. The authors then write, while the Senate Repeal Inquiry's report made the above-mentioned recommendations, it did not really take a consultative approach to the review. The report did not systematically test the government's proposal, and it didn't consider alternatives to such a proposal to allow for a compromise to be reached. Consequently, the fragmentation of the policy community remains, end quote. The paper then moves to the next topic referred to in the heading, the National Commission of Audit, which was established by the Abbott government. The authors quote its objects, which was to, I quote, review the scope, efficiency and functions of the Commonwealth Government. Its purpose was to, quote, identify areas of Commonwealth Government activity which requires change in order that the Commonwealth might live within its means and begin to pay down debt. The authors spell out its functions, including, I quote, ensuring taxpayers are receiving value for money for each dollar spent, eliminating wasteful spending, and identify areas of unnecessary duplication, end quote. The authors describe that as the new public management theory. Many might think it better described as a proper function of government. They write, with the election of the Labor government in 2007, a shift from the new public management model to a more relational governance model seemed to have started. After the election of the Abbott government, any pretext of working within a relational governance model has been put aside with a return to the new public management theory. The aims and language of the National Commission of Audit, which considers that competition, efficiency, restrained resource allocation and performance measurements are key to the way the reforms are shaped, resonate strongly with the ideas that underpin new public management theory. This is also cemented by NCOA's hostility towards public debt. Part 6 is the conclusion. It's entitled, Where to Now? It states, I quote, the focus of the current government is on cutting red tape and dealing with budget constraints. Influenced by the new public management theory, these two problems are driving the government reform agenda for the not-for-profit sector. However, such an approach pays minimal attention to accountability, harmonisation, and reaching consensus with the sector, end quote. Having addressed accountability, harmonisation, and reaching consensus, the authors conclude as follows. Lastly, in completing its consultation and reaching a solution, the government should pay attention to all the concerns of the sector and the community at large. A serious consideration needs to be undertaken about the manner in which the current alternatives put forward by the government may deal with the concerns of the sector and the wider community. Accordingly, the authors conclude that the government cannot hope to achieve its policy objectives of abolishing ACNC unless it adjusts its policy settings. This reality is becoming more apparent today as the government no longer treats the repeal of ACNC as a priority. The authors then give advice. It is this. If it, that's the government, does want to pursue a change in the status quo, the government has to fine-tune its proposal, conduct consultation with the sector and the community, and be willing to compromise. In view of the strong support of the ACNC has from the sector, the government will have an uphill battle to succeed in this quest. The current composition of the Senate makes it imperative that any proposals for change be accompanied by demonstrable sector support, as many senators are hostile to the current proposal. A compromise may result in retaining the ACNC and introducing a centre of excellence that plays a key role in enhancing good governance for the not-for-profit sector. If the government decides to change its position and support the status quo, the current regulatory framework may help the government implement its new public management theory, improve accountability and harmonise the system. In the end, a clear position by the government is needed. Currently, the government notes that while the removal of ACNC is still on the table, it's not a priority on its agenda. Such a position causes instability and uncertainty in the sector and prevents the ACNC from conducting its role and achieving its aims. The situation is unacceptable and has to be remedied as soon as possible, as it weakens the regulatory system and sends the wrong message to the not-for-profit sector in Australia and overseas. End quote. Whether all of that is sound political advice is for others to judge. But I think that the views expressed have little, if anything, to do with the law. It is for politicians, not lawyers, to decide upon such compromises as may be necessary to achieve the passage of legislation, and whether such compromises are in the public interest. That's why we have parliaments, that's why we have elections. Politics and the law are very different. Politics is frequently based on compromise. The law is always based on principle. This is something that lawyers should always remember. The final paper in the theme section is by Miss Brodie, entitled Uncomfortable Truths, Protecting the Independence of National Human Rights Institutions to Inquire. This well-argued paper sets out to defend both the independence of the Australian Human Rights Commission and its chair, Professor Triggs, and the Commission's right to inquire as it sees fit. The author explains that the Australian Human Rights Commission is an institution which, consistent with principles which have spread widely, particularly since the first international workshop on national human rights institutions convened in Paris in 1991, from which the so-called Paris Principles evolved, is an Australian-created institution intended, I quote, intended to have a legal foundation independent of the state that created it, and it should be granted formal powers sufficient to undertake their promotion and protection mandate, end quote. The central elements of the Paris Principles are said to be that, and I quote again, the NHRI, that's the National Human Rights Institution, is established with a broad human rights mandate, that independence from government is guaranteed by the Constitution or statute, that membership of the institution is composed of pluralist representation and secured by official appointment, that NHRI works closely and appropriately with civil society, that NHRI is endowed with sufficient resources, and that NHRI is granted a range of monitoring and advisory functions supported by powers to operationalise them. There is no examination in the paper of whether the Australian Human Rights Act of 1986 confers upon the Commission that degree of independence or powers, although the author's encouragement to the Commission and NHRIs to, quote, creatively interpret their mandate, end quote, suggests there may be some difficulties in this respect. The author recognises an, quote, inherent tension in the concept of an NHRI. States which establish an NHRI may not want to be held to account by an independent, powerful and well-resourced entity, end quote. She further states, at the centre of inquiries conducted by NHRIs are grievous human rights violations. All national inquiries will seek to create change, to stop systemic or widespread abuse, and to encourage the internalisation of human rights norms. I presume that those words were not intended to suggest that the outcome of inquiries is known before they are conducted. Those passages that I've just read you, however, do go to the heart of the inherent tension referred to. A sovereign state, here Australia, by legislation, establishes and funds an independent body and confers upon it investigative and advocacy powers. The body so established has no power to make binding determinations. It's not a court and it can't bind the Commonwealth. It can only report and make recommendations to the Parliament which created it. The government of the day may accept or reject those recommendations for any number of reasons which it regards as sufficient, including conflicting policy or monetary considerations. If rejected, the NHRI may then seek to persuade the public that rights or obligations that are not a substantive part of the domestic law in the sense of conferring enforceable obligations, which domestic law, by the way, the Parliament controls, should become so, the so-called internalisation of human rights norms. That conflict raises three distinct issues which desirably should be addressed separately. The first is whether the Commission has the right, conferred by its constituting charter or statute, to conduct the particular inquiry. That issue will be determined by conventional methods of statutory interpretation. The second is whether, having conducted such inquiry and reported to government, the government is obliged to adopt recommendations of the Commission. The author seems to accept that the government is not so obliged. The third is whether the government, or indeed members of the public, are entitled to discuss, analyse, or criticise, first, the Commission's decision to conduct the particular inquiry, and second, its recommendations resulting from that inquiry. Those three issues are quite separate from the legitimate endeavours of the Commission, whether by holding an inquiry or advocacy, to encourage the internalisation of human rights norms. The author's thesis, as I understand it, is that there should not be any such criticism of the Commission or its chair, because that may constitute an attack on the independence of the national human rights institutions to inquire. The author accepts that NHRIs must be held accountable, presumably to government. However, she then states the accountability must rest on the NRHR's mandate, has it sought to fulfil its responsibility to promote and protect human rights, end quote. It's not clear to me whether the author intended by that sentence to prescribe the only permissible criticism of the NHRIs. The boundary between criticism based on accountability and criticism which is said to be an infringement of independence is not explored in the paper. If criticism is permissible, and the author accepts that it is, I suspect the judgment of that criticism will not be determined on any empirical basis, but on the basis of social or political views. Presumably, that is why the author cites the views of politicians, journalists, online commentators, academics, and prominent Australians, which I would have thought would be included within academics, but anyway, as authority for the proposition that what she describes as a personal attack on the chair was not supported by many. To me, this is a new concept of legal correctness or authority, as distinct from social or political correctness. Public views on any topic, even if they can be established, are not indicia of legal correctness. It seems to me that there is some mixing of law and sociology. But be that as it may, if there is a right to applaud the actions of the Commission in inquiring or the substance of its recommendations, and the author provides considerable evidence of such applause, it would seem difficult in a democracy to suggest there can be no criticism. The legitimacy of such criticism will usually be a matter of political debate rather than legal determination. Although I have in the past bemoaned the fact In modern times, the courts and the judiciary, perhaps the epitome of independence in our society, are frequently criticised. Yet their independence remains. It is an interesting and, to my mind, novel concept that criticism might, in some fashion, diminish a statutorily conferred right to inquire, or its independence so to require. The readers of this volume of the New South Wales Law Journal will be stimulated to think more deeply about a wide range of topics. That, in my view, is a principal function of such works, for it's only by such stimulation that our legal concepts are developed and enhanced. The scholarship here is of the highest standard. I congratulate the contributors for their scholarly work, the editorial board, and in particular the editor, Mr. Wang, on selecting and producing this collection of articles. Thank you.
Good evening, everyone. My name is David Dixon. I'm Dean of the Law School. It's my fortunate duty to deliver the vote of thanks, and particularly I'd like to thank Mr. Terrence Cole for that wonderfully close reading of the articles which are in tonight's issue. We're very lucky to have someone with his wonderful experience. I think nobody in the country has got more experience of doing the kind of inquiries that we're talking about tonight. So thank you very much for those really interesting and valuable remarks. Thank you also to our hosts from Freehills, and I'm repeating what was said before, but the connection between Freehills and this journal is of great importance and has been for a long time, but it's part of a more general relationship between Herbert Smith Freehills and UNSW Law, which has been going from right back to the start of UNSW. We had an event at the university a few weeks ago to thank Herbert Smith Freehills for all they do, because it's not just the journal, it's also the library. They have, for more than 20 years, have been giving us a solicitor to work full-time in Kingsford Legal Centre, an extraordinary commitment which is not matched by any other firm. And they're also funding currently, amongst a number of other things, they're funding a new initiative in law and economics with my colleague Rosalind Dixon. So thank you very much. It really is very much appreciated, and it's great to see some of our best students coming on to work here, which leads me on to the next point, which is to give my thanks and congratulations to everybody who's involved in the journal. The people who've been, the old lags of the journal alumni will be sick of hearing me say this, I know, but I'm going to say it as I always do. The people who are involved in editing the Law Journal are amongst our very best students. It's something that I'm very proud of, that our journal has now got the kind of status of the best US law school reviews, where being an editor of Law Review is in itself something that recruiters, employers will look to on a CV as a real mark of distinction. And the work which has been done by this year's editorial team under James Norton, and particularly Zhong Wei's issue tonight, I think really hold up a very, very long and really excellent tradition. So congratulations, everybody. And just to again repeat the point, I'm here to say thank you. I don't have any responsibility for the journal. Anytime my academic colleagues try and get ideas about, we should tell them to do this, we get put back in our place very firmly, and that's exactly how it should be. So it is a student-run, edited and controlled journal, and I'm very proud of that fact. Finally, I'm actually not like a very good Royal Commissioner in that I'm never very good at sticking to my terms of reference. So I'm just going to go, as I usually do, I'll usually cause a problem by going slightly beyond my terms of reference of delivering a vote of thanks. And just a quick comment about the substance of tonight's special issue. The point about it being about non-judicial inquiries, it's of great interest to me because of my background in the UK, where focusing particularly on royal commissions, that royal commissions in England are I was very surprised when I came here to see the way that, although they are, as Mr. Cole and Peter McClellan say in his introductions, they are non-judicial in that they're not carrying out judicial functions. They are much more curial than an English Royal Commission would be, that they're usually chaired by judges here, and they have a much more judge-like, court-like character than the typical English Royal Commission. And I'm not in any way saying that one is better than the other, but simply that you can learn some, both sides I think can learn from different ways of doing things. Particularly the way in which the relevance to us as academics is that one of the benefits of the English approach to it has been to allow a greater flow of influence from academic research into the Royal Commissions. And if you look in my area, which is criminal justice, there was two very influential Royal Commissions, first on criminal procedure, then on criminal justice in the last century, both of which were chaired by academics rather than judges, and which were made up of a large panel of people who came from included some professionals in the area, like police officers and judges, but also a wide range of other people. And relevantly, what they did was both of those Royal Commissions commissioned a wide range of research reports by academics into the areas which were being inquired into. And I think that was one of the reasons why, particularly the Royal Commission on Criminal Procedure had such a massive impact on changing the way in which police investigations are done and the way in which evidence is used in criminal courts in England very successfully. When the Wood Royal Commission into the police started here more than 20 years ago, at one stage I was asked to go and work for them, and my response to it was to say, well, why don't you, rather than doing that, why don't we try and do something a bit like the English approach of having a wider academic input into the Royal Commission. And it led to a kind of rather bizarre incident when I went down to the Royal Commission with me and a couple of my colleagues, Mark Finane, who is the leading police historian in this country, and my colleague Janet Chan, who is a sociologist who's the leading international writer on police culture. And there were three of us sitting on a sofa in the Royal Commission's executive officer's room. It's a bit like budgies sitting in a line. Me, the criminal justice lawyer, Janet, the sociologist, and Mark, the historian. And the guy, Brian Davis, said to us, "Why do we need three of you?" You know, it's just this idea that you're academics all the same. Anyway, we managed to, I think, talk them into seeing that there might possibly be uses for more than one. And in the end, I think it's one of the things which distinguished the Wood Royal Commission was that there was a wide range of research papers which were produced by the three of us and a couple of other people who got involved, which were eventually published externally as well. And particularly the work by my colleague Janet Chan, who's now a professor in the UNSW Law, had a very significant influence on the Wood Royal Commission's report on the work on police culture and about how you change the police. And if you look back to the way things were in the police 25 years ago in this state and look to how they are now, you'd see that there have been really, really substantial changes. Now, having said all that, in terms of influencing criminal justice policy, I'm not sure that Royal Commissions are quite the thing. I think, unfortunately, those who rule us are more likely to turn to the August pages of the Daily Telegraph to find out how to change criminal justice policy. But it is still an idea that, in fact, academics may be able to make the odd contribution of value, which may well stray. I think Mr. Cole might think stray a little too far beyond the strict lines of the law into politics and sociology, which is these days part of our stock in trade, frankly. But I think it is something that we can actually manage to do quite well. Anyway, that's my little diversion. Said my little extra piece. So thank you very much, everyone, for coming tonight, and congratulations again to everyone involved in the journal. Thank you to Freehills, and special thanks to Mr. Cole for those really inspiring remarks. Thanks.